Hi, I'm Steve Bohm, and welcome to our panel, Cannabis, the SEC and BDCs. I'm joined today by two of my partners, Owen Pinkerton, an experienced securities lawyer who spent time in his career at the SEC, and Greg Kaufman, a litigator who heads our cannabis program. Today, we're going to talk about regulation that relates to cannabis, both on the federal level and the state level. And we'll talk about how products have gotten through the SEC, both in terms of the Division of Corporation Finance and the Division of Investment Management. Right now, I'm going to ask Greg to give us an overview of the background of regulation of cannabis in the United States, both at the federal level and the state level. Greg?
Thank you, Steve. So as it stands right now, there are 36 states in the District of Columbia that have legalized medical cannabis. And I may jump between using the phrase cannabis and marijuana, but they are the same thing. There are a handful of states that have what we call low THC or CBD programs. Those are very restrictive medical programs that are really intended to only service a small patient group dealing with severe epilepsy issues. Those tend to be concentrated in more of the conservative states in the country. And then there are 19 states in the District of Columbia that have legalized adult use or recreational use of marijuana. To give you some idea of how far we've come in a short amount of time, in 1996, California was the first state to legalize medical marijuana by ballot measure. In 2012, Colorado and Washington State were the first to legalize recreational use also at the ballot. And that's kind of a common theme in the early part of this industry is much of the legalization efforts have not gone through the legislature, but rather have gone through the ballot box. So that at the state level, we have a very highly regulated state by state system in place. At the federal level, and this won't be a surprise, I'm sure, to the audience, marijuana is still a controlled substance. It is a Schedule I controlled substance under the Controlled Substances Act. It is illegal to grow, sell, or possess. And that the reason why it is a Schedule I drug is because it is deemed to have a high potential for abuse and no recognized medical use, which is interesting because we have 36 states in the District of Columbia with medical programs, yet under federal law, there is no recognized medical use for marijuana. So under the Controlled Substances Act, that is the primary federal law that everyone worries about in the industry. For this audience, there's kind of three areas of federal law that they need to be aware of. And these are primarily dealing with those who provide services to the industry. And I'm looking at them from that perspective. The first is aiding and abetting under the Controlled Substances Act. So, are you assisting in the commission of illegal activity? And there's a feeling that, and that can be overcome through legal opinions based on the fact that you're not actively participating in the business. If you're a passive participant, there's probably not aiding and abetting liability for those providing services to the industry. There's also drug paraphernalia laws, which basically say anything used to manufacture or consume an illegal substance like cannabis at the federal level, that can be violated, if you're providing the grow lights or the soil used to grow. That's the area that people are concerned about. However, when those products have dual uses, grow lights can be used for lots of different things. Soil can be used to grow, any kind of crop. That is unlikely then to be a problem under drug paraphernalia laws. And then there's the Money Laundering Control Act, which basically says you cannot deal in the proceeds of illegal activity. And this is an area that gets a lot of attention. There are very good legal arguments out there to say that if it's not proceeds from a specified unlawful activity, then you are not actually dealing in illegal proceeds, and you're not violating the Money Laundering Control Act. So that is what people have relied on to get around that problem. And it's even an issue for lawyers. If we're advising cannabis companies, are we dealing, when they pay us, are we dealing in proceeds of illegal activity? And it's been determined by many scholars out there that we are not. So to give a little bit more background on kind of where we are, particularly at the federal level, we could go back a long way, but we're not going to do that. We're going to start at 2013, when then Deputy Attorney General Coal issued the Coal Memo, a very important memo in the industry, because what it said is the Department of Justice is not going to prioritize prosecuting cannabis companies if they are operating legally under their state regime and they're not violating kind of some of our priorities, which would be, making sure children don't get access to the drug, making sure organized crime's not involved. So that memo was a really important thing. 2014, in the appropriations bill, the Rohrabacher-Farr amendment was put in. It's been in every appropriations bill since, and it's actually now being discussed in the current discussions for the upcoming fiscal year. And that basically said the Department of Justice cannot use any money appropriated to it in order to prosecute medical cannabis companies operating legally under their state regime. There have been efforts to add a provision to cover the recreational marketplace as well. It has always failed, but they're going to try again this year to get that amendment put in. In 2018, I told you about the Coal Memo. Well, Jeff Sessions, then Attorney General, revoked the Coal Memo. Even though it was revoked and has not been reinstated, the industry really does operate under the old Coal Memo kind of regime, and that's worked, I think, pretty well for them. Also in 2018, a really important thing happened. The Agricultural Improvement Act was passed, otherwise known as the 2018 Farm Bill, that redefined hemp and cannabis and basically made hemp a legal agricultural crop. Hemp is anything, is a cannabis plant with 0.3% delta 9 THC or less. And anything above that is considered marijuana. The exact same plant, the only difference is how much THC it has. And then in 2021, during his confirmation hearing, now Attorney General Garland said he did not believe that using Department of Justice resources to go after legal cannabis companies at the state level was a good use of limited resources. So the bottom line is, in the last 7 years, there have been no criminal actions against state compliant companies at the federal level.
Greg, that's very informative. A follow-up question. How would you handicap the likelihood that federal legislation will pass in this Congress or any other Congress that would officially put the cannabis industry off limits to the Justice Department?
Yeah, well, I think there's a chance that the amendment in the appropriations bill, which would keep the Department of Justice from spending money to prosecute at the state level for recreational use, that has a chance of getting in this Appropriations Act. There are a number of pieces of legislation in Congress. The most significant one, the Cannabis Administration and Opportunity Act, I have to get my acronym straight, which was proposed by Schumer, Booker, and Wyden just a couple weeks ago, is the most comprehensive legalization bill at the federal level we've ever seen. I don't think it has a very good chance of passing. I think it will be difficult to get 60 votes in the Senate. I think it probably will pass the House. And we have to remember that the current President Biden is not a fan of the industry. He has talked about decriminalization, but he is not in favor of legalization. And if you remember, when he first got into office, there were a number of employees who at the White House who admitted prior cannabis use, and some of them were fired for it. So, even if a bill were to get in front of the president, it's not clear that he would sign it.
What's the difference between non-legalization and non-enforcement?
Well, I think for the industry, it's a big, and for people looking to invest in the industry and be participants in the industry, it's a big difference. Non-enforcement is where we are now. But there are laws out there that say it's illegal. And for a lot of businesses, that's enough. They don't want to touch the industry if under federal law it's illegal. If that barrier drops, well then, Katie bar the door, everybody's coming in.
Well, given that regulation, as you've just described, it varies from state to state, and you have a ambiguous federal position, how should folks in the registered fund and BDC industry think about how they should pursue opportunities in that business?
Yeah, you really have to look and understand the regulatory regime in each state of which you're looking to invest in. Each state has their own unique regulatory structure. There are, for example, there are limited license states. I'll say Maryland is a good example of that. There are only so many licenses that can be allocated, which gives an advantage to the license holders. Those licenses are more valuable, and they have an advantage in that marketplace. You go to a state like California, where you don't have limited licenses, and those licenses aren't quite as valuable. You have a lot more competition in states like that. So you really have to understand the regulatory regime. You also have to understand the license transfer process. If you are going to be an equity owner, in some states, if you invest $1 in a cannabis company in equity dollars, you have to be approved by the state as an owner. You have to go through a criminal background check, and you have to disclose financials and things like that. So it is critically important to not look at this as a national interstate business, because it's not. It is a state-by-state business where if you're a company operating in more than one state, you have to recreate your operations in each state, because you can't move product over state lines.
That's very helpful. Thank you, Greg. Let's turn now to a discussion of the SEC's views on issuers interested in the cannabis business. There's been some ambiguity and inconsistency between the two divisions that handle issuers of securities, the Division of Corporation Finance on the one hand, and the Division of Investment Management on the other. Owen, why don't we start with a discussion of what CorpFin has been doing with respect to registrants seeking effective registration statements and the ability to sell securities in companies investing in the cannabis business.
Sure, thanks, Steve. And there's definitely been some ambiguity and inconsistency for sure. Division of Corporation Finance, I think it might be helpful to start with its mandate and the statutes that underline what they do. I mean, number one, Division of Corporation Finance reviews operating companies, registration statements for operating companies, and related businesses. So they don't look at investment companies. They only look at more operating businesses. The Securities Act of 1933 is more of a disclosure-oriented regime, where the thought is that if the disclosure is full and fair, that investors are smart enough or have the information they need in order to make an investment decision. And so corporation finance has, and this is more recent, this hasn't always been the case, but in recent years, they have been reviewing and permitting, or not approving, but bringing effective registration statements for cannabis operators and owners, cultivators, growers. So they have, there's been a significant amount of risk disclosure in those documents, but the issuers themselves have been able to have registration statements declared effective. The gating factor before, and this is starting to break away a little bit, but not entirely, is the exchanges, the major exchanges, New York, I'll just talk about New York and NASDAQ really. Both of them have provisions or rules that any issuer that lists their securities on the New York Stock Exchange or NASDAQ has to be complying with all federal laws. They have, well, not just federal laws, but they need to be able to provide assurances to the exchanges that they are compliant with all applicable laws. And so the cannabis operators that are getting through Corp Fin with their registration statements largely are on the over-the-counter markets. And so their securities do trade, but they're not on the big exchanges. They're not on a national securities exchange. So you can buy securities of, various cannabis operators over the counter. But if you want to have the proper liquidity and all the rules and regulations that the major exchanges have, they largely have blocked these kind of efforts. The one area where there's been an exception, and this has changed a little bit recently as well, is with real estate investment trusts or REITs. Back, I guess it was in 2016, the New York Stock Exchange approved the listing for innovative industrial properties, which at the time was a property REIT, an equity REIT that provided that owned properties that were engaged in the medical cannabis space, and their initial registration statement actually was limited to medical. Over the years, that has changed. It's not just medical; it's also for recreational use as well. There's just they don't draw the distinction anymore. And anecdotally, what the story has been that the thought was that legalization was on the horizon. This was 2016. I think the expectation was that Hillary Clinton was going to win the presidential election, and that all the cannabis efforts that were moving forward were going to continue to move forward, that the momentum from the Coal Memo and others was going to continue. And I don't know if they jumped the gun, or I don't know what the proper way to put it is, but they did approve the listing for innovative industrial properties. When Donald Trump won the election instead, that did change the landscape, as Greg talked about, and subsequent efforts for a property REIT to be listed on the New York Stock Exchange were rejected. So that was, at the time, that seemed like a one-off event. More recently, there's a mortgage REIT, AFC Gamma, that had its registration statement declared effective, and it's a mortgage REIT, so it lends to cannabis operators and others involved in the cannabis space. Looks a lot like an investment company. The difference being that its investments are fully secured by real estate, so it's able to qualify as a REIT. The NASDAQ has approved the listing. It's been trading for a couple of months now, and that seems to signal a shift in their willingness to, because you could take the position that this is aiding and abetting, but I think, as Greg pointed out, there's a lot of gray area there, and there's also you can assist companies, or you can provide assistance without actually aiding and abetting under federal law, and so NASDAQ took the opinion, and I think that they received a legal opinion to the effect that what they are doing does not violate federal law, and so therefore it's consistent with NASDAQ's mandate and its rules and regulations. But at the same time, they do lend to plant touching cannabis operators and other entities. So it's been an interesting shift, but that's where things are right now, and it's not clear whether this is, the door is wide open, or if it's going to be a case-by-case basis. I suspect it's the latter, that this is not a go ahead, like Greg said, Katie bar the door. I don't think that's the case. I think this is a case-by-case basis, but it has been a shift.
Does CorpFin require an opinion of counsel in order to declare a registration statement like AFC Gamma effective?
No, no, CorpFin did not.
Well, that brings us to an inconsistency, which we suggested early in the program, and that is, can you talk a little bit about how the Division of Investment Management, for its part, handles cannabis registrations?
Yeah, so that's been a lot different, and so this first came up with a couple of ETFs that wanted to invest in cannabis, so the equity of cannabis issuers. And we'll talk a little bit later about the distinction between debt and equity, as far as what that means, as in terms of violating or not violating federal law. But the ETFs were one of them, well, they had the word cannabis in their name, first of all. So that drew the attention of the staff, and the staff, I don't think there's any written correspondence directly from the staff on this point, because these were ETFs that were able to file for a new series without actually having to file a brand new registration statement. But in the process, the staff required that they provide an opinion from counsel that basically said that their activities are legal. They're not violating federal law. They're not violating the Controlled Substances Act. They're not violating the Money Laundering Control Act or any other federal law. And the way that the opinions are structured is that number one, they review, well, in the case of the ETFs, and we'll stick with that right now, they reviewed the intended investments or examples of in companies that they would invest in. And they would ensure that they were not engaging activities in the US that would violate federal law. They also required that all securities held by the ETFs would be traded on a limited number of exchanges. And so those exchanges were NASDAQ, NYSE, some Canadian exchanges, others. And this goes back to the point about NASDAQ and NYSE having rules that their issuers will not violate federal law. So the opinion basically was able to build on that and say that if NASDAQ and the New York Stock Exchange have agreed to list this company, they've made a determination that their activities are lawful. Therefore, if they've made the determination that the activities are lawful, we're comfortable that if you invest in those companies, you're not also engaged in violating federal law. And so that was the main crux of the opinions. There was one opinion subsequent to that took it one step further that's kind of interesting to note. And this is very much form over substance, which is something that investment management doesn't always like, but apparently in this case they were okay with it, is one of the opinions permitted the ETF to invest in total return swaps where they got exposure to cannabis companies that are plant touching, but they don't own an equity ownership in it. So you can't make the opinion says you can't make the argument that they're aiding and abetting the plant touching company because they don't own any security. They own no interest in it. None of the proceeds go to that company, nothing. The benefit to them, of course, was that they could get exposure to companies that have different risk reward characteristics, and they could also name them in the financial statements. Under the total return swap, they say we have a total return swap that represents exposure to this issuer and this issuer. So it's sort of the best of both worlds. You get to get the exposure to the companies that you want to have exposure to, but you don't actually own an interest, and you don't risk violating federal law. Or the staff was also concerned about what is the impact on shareholders? Are shareholders going to be deemed to be aiding and abetting by owning shares of the ETF? And so that was another reason for the opinion and another benefit to the total return swap structure. And so the SEC did accept that in that opinion. I've only seen it in one situation, although I guess there could be others, but this only comes up when the name cannabis is in the fund's name. The word cannabis is in the fund name or some derivation of that. That's when the staff focuses on this.
Well, it's interesting. Obviously, the Division of Investment Management has a different view from that of Corp Fin. Has IM published any guidance, or is this all anecdotal with respect to each filing?
It's largely anecdotal. So some of the comment and response letters are publicly available, but these were oral comments that were issued by the staff, and so I always get a little bit nervous about putting too much weight in how outside counsel has decided to interpret an oral comment. In this case, it could be that the oral comments were very were spelled out, and they wanted to make sure that this is exactly what you say in your response letter. But I don't know if that's the case. There's no written guidance that I'm aware of from the staff on this point.
And of course, for practitioners in the 40 Act space, IM is very different from CorpFin. It tends not to have guidance, and there tends to be inconsistencies even within the division at times, depending on which examiner you have and what their chain of command is. So we'll look forward to getting some more guidance, hopefully from IM. Speaking of funds, what about funds that don't have a specific cannabis focus or a name that doesn't involve cannabis? How does the staff treat them?
I haven't seen anything on that point. I think, you know, you can pull up scheduled investments for registered funds, and you might come across a plant touching company here and there. But if cannabis is not your strategy, or if it's not in your name, then the staff hasn't required any sort of opinion and I haven't seen any comments from the staff to issuers saying you need to divest of this position because it's a plant touching company. I haven't seen it. That doesn't mean it hasn't happened, but I haven't seen it. I don't think that they're focused on that.
Well, we've touched on CorpFin's view. We've touched on IM's view, such as it is. What about the exchanges? How are they handling requests for listing where there's a cannabis focus?
Yeah, so I think it's largely on a case-by-case basis. I mentioned the innovative industrial properties that was approved in 2016. There was one after that, Treehouse REIT, that wanted to largely follow what Innovative Industrial did and the New York Stock Exchange. And there's public correspondence to this effect. It was a very detailed response from Issuers Council trying to get listed, and the NYSE said no. They changed their position on that. So they are both sticking very much to the position that the activities need to be lawful at the federal level. Now, what that means exactly might have shifted a little bit. I think there might be more room for an issuer like that now, especially with the AFC Gamma being approved by NASDAQ. And NASDAQ, I believe that they received an opinion from counsel that provided assurances that the activities are legal, but they wouldn't. They also had to come to that conclusion on their own. They wouldn't just accept an opinion and move forward. So they've moved in that direction. I don't know if NYSE has changed its position at all, or if it's more open for business. I think that's kind of an open question right now. But there certainly has been movement. I think the exchanges, to some extent, the SEC had relied on the exchanges to kind of enforce their position. And so if the exchanges move a little bit more, that puts more pressure on the SEC to loosen its position as well.
Helpful.
So actually, on that point, if we switch gears to BDCs, there was recently a filing, or there is a file. There's a registrant on file right now with the SEC, Silver Spike Investment Corp, that is a BDC. They elected to be a BDC, and they have a registration statement on file, and they propose to lend to cannabis companies. Steve, can you walk through what that filing looks like? Any opinion requirements and any sort of differences you see there in the BDC space as opposed to the registered fund space?
Well, there is a difference. BDCs are a peculiar creature. Among other things, they're required to provide managerial assistance to portfolio companies if it's requested. But more generally, the Silver Spike registration is very significant. It did get through the SEC, and it did price. So there is ample evidence that the Division of Investment Management is willing to let BDCs go to the extent they're satisfied with the opinion that's provided. Now, what are the conditions that they'd let them go is reflected in the opinion. Number one, they're lenders and not equity investors. There's an argument that is more palatable because as a lender, you're not really an owner of the business. You're, in effect, a service provider to the business. You're providing loans. Number two, with the issue of managerial assistance that I mentioned, generally BDCs are required to offer managerial assistance and to provide it if the borrower so requests. Here, of course, that would present an issue to the extent the BDC got involved in the business of cannabis. One could argue that they're going against, well, not only argue, they're going against the condition of the effectiveness of the opinion that they provided to get effective. So what the SEC has said is the guidance that a BDC can give under the category of managerial assistance, again, if requested, is operational. It can't go to the growing, it can't be plant touching advice. It has to be advice relating to the running of a business. The other condition that's important is that you can't have an interest in real estate in which, on which cannabis is being grown. That is consistent, interestingly, with AFC Gamma, which, although not regulated by the Division of Investment Management, as Owen mentioned earlier, is a mortgage REIT. In fact, AFC Gamma looks a lot like a BDC because they're lending to cannabis growers and others. The difference is that they're not regulated under the 1940 Act because there is an exception for REITs and particularly mortgage REITs. So they're not regulated by IM. But we view Silver Spike as very significant. It may very well open the door to others who are willing to give the same opinion and live with the same limitations. So there may or may not be an avalanche of BDC registrants, but we're looking at this closely.
Thanks, Steve. Yeah, it's very interesting, and it's something that I think, you know, the staff took very seriously. If you take a look at the opinion, it's a 20+ page opinion, so it's much more significant in size and scope than what the ETFs have had to provide. So it is it's an interesting development. So, you know, obviously this is an area that's changing day by day, and you know, we sort of had to check Edgar almost just to see what happened yesterday, because there could be a new filing that we didn't mention. It is moving, you know, very, very fast. So what do we, I'm going to ask each of you, what do you see going forward? Like what's next, or what do you see, you know, on the horizon, not just with respect to registered funds and BDCs, but just in general with the regulation of cannabis in general? Greg, do you want to start off?
Sure. Oh, and I think your description of it changes every day is an apt description. This area moves so quickly. I mean, it's projected to be have $30 billion in sales next year. As I mentioned, it's highly regulated. It is also very highly taxed. It's a capital intensive business to be in. And there is a real desire in the industry to move away from equity financing and sale leaseback arrangements where they're paying pretty onerous, or on the REIT side, premium rates, and to really start getting into debt financing. There's a desire for that. It's starting to come into the industry, but right now the need is not being met by the lenders. So I think there's a real opportunity there. You know, I think that those looking to lend in this space or to provide capital in this space need to watch the federal legislation. I mentioned I don't think the CAOA is likely to pass, but it has kind of set the floor. We now have a real legitimate federal bill to start discussing and debating. And it's really important to understand the various pieces of federal legislation that are out there, and that how that it could impact the industry. As I mentioned before, you know, if you are a vertically integrated company, meaning you grow cannabis, you process it, and you sell it at retail in various states, you have to recreate that chain in every single state. If federal legislation allows you to move interstate, well, does that model really work anymore? You have a lot of assets that aren't really that valuable because you don't need cultivation in 5 different states when you can have it in one and then move it into those other states. So it's really important to watch what is going on at the federal level. And meantime, you know, I think the wave of states legalizing both medical and recreational cannabis is going to continue. There will be more states either through the legislature or more likely through the ballot box that legalize in the coming years. So, you know, watch the 2022 election. There'll probably be a few ballot measures. I think Ohio is primed up for that. But the march goes on whether the federal government legalizes it or not.
Well, on the security side, as I like to say, imitation is the sincerest form of Wall Street. So we're going to look closely at what AFC Gamma does. It's trading. It seems to be trading well. We're waiting to see the trading of Silver Spike. And I think to the extent either or both of these succeeds, you're going to see many more filings. The interesting thing is going to be whether the Division of Investment Management starts to codify its positions in some kind of writing. At this point, it's ad hoc, and there's no guarantee that someone coming in on the same basis as Silver Spike will get out, although one is hopeful that there'll be a consistent position at the Division of Investment Management. Another interesting question is, Silver Spike was a blind pool. Will folks come in with assets that shareholders can see and make an educated judgment on? Will that make it more successful or less successful? We're waiting to see that. What about registered funds or BDCs that are not focused on cannabis, but rather make periodic investments in companies that touch the cannabis business? How will the SEC react to that? Will they require something more than risk factors? Remains to be seen. And we wait to see if CorpFin and IM can decide to have the same approach. That is, whether CorpFin goes to requiring an opinion or IM goes to no longer requiring an opinion, waits to be seen. And that could dictate whether a cannabis-based product would go as a mortgage REIT like AFC Gamma or as a BDC like Silver Spike. So lots to be seen. We'll be watching this very, very closely. Well, that's all the time we have. We've enjoyed presenting this. It's a subject that will be evolving over time, and we look forward to keeping our clients and our friends updated. Owen, do you have a last word for our friends?
I think you nailed it. It's something that I almost feel like, using a securities law expression, I almost feel like we're going to have to sticker this presentation. We're going to have to update it once or twice in the next month or two, because there might be new developments that maybe 1 or 2 months is too long. But we might have to update this a couple of times. But no, I think it's something that we just have to keep track of, and it's a very interesting space. It's a growing space, and there's a lot of opportunity here.
Greg, I'll give you the last word. We're sitting here 2 years from now. I have even less hair at that point. And the question is, what will we see? How will the world change, if at all, in your judgment, when it comes to cannabis investors?
I like the term "watch this space." I was going to end with that, but to answer your question, I believe we will be in a very similar situation to the situation we're in now. Meaning, I do believe we'll still have federal illegality, and I think we will have even more states legalized. We will reach a tipping point, frankly, where and arguably we've already reached it, but we will reach it, I think, in 2 years, where that dichotomy just doesn't make any sense anymore, and something has to be done. And then I think we'll be in a better position for federal legalization.
Well, great. And I'd like to thank all of our registrants who are taking a look at this. And we're welcome to answer questions. You know where to find us at Eversheds. And we wish everybody a nice day.